anybody else joining the call. Tyler, I'm going to wait till you hit record to begin fully.
All right, should be recording.
Thank you, Tyler, so much. Good morning or good afternoon, everybody. Thank you for joining today's quarterly call. We are so excited to have you here after quite a pause. We are excited. We've been working so hard to share with you kind of what we've been doing and where we're going. And the newest updates. And I know you guys have all, have had your eyes on these executive orders and you're wondering, what to do or what not to do. And we finally have some answers. We have a pretty full agenda today. We're going to, start out with, our very own NIFA director, Vidal Gray, talking to us about his opening remarks. And then we are going to move to Mr. Terrence Maynor, kind of talking about the recent executive orders and understanding them and kind of what they mean. And then we're going to go on to discuss best practices for continued compliance by Mr. Josh Galliotto. And then I will talk a little bit about risk mitigation and enforcement. And then we'll move on to the FAQs that I know you've all been waiting for. And then we have a really special guest today that I've really enjoyed working with this past year, and that's Ms. Ramonda Reed, Director of the Compliance Division at OASCR. And then back to Vidal again to close out. So with that said, Vidal, I'm going to turn it over to you.
Thank you very much. I appreciate it. Good afternoon to everyone, and or good morning to some that are out west, further out west. So we're going to go ahead and get started. So I want to talk about the purpose of this session. So the purpose of this session today is to provide essential updates regarding significant shifts in our procedural landscapes. As we navigate these changes aimed at ending certain government DEI programs and preferencing, it's going to allow us to focus on restoring merit-based opportunities and ending illegal discrimination. These adjustments are crucial to maintaining legal alignment and adhering to the highest standards of fair and merit-based operations across our organizations. Our commitment will remain steadfast. We must ensure that our processes are transparent, lawful, and that every individual is treated with equal dignity and respect. With that being said, let's jump into the presentation. Thank you. Terrence?
Thank you, Mr. Gray. Everyone, good afternoon. Thank you so much for joining us today. Like Mr. Gray said, Ms. Shabnam said, I'll be briefly going over these executive orders. Just provide a brief overview of the orders and the ones been enacted since January 20th, 2025, and why you shift your programs and activities to align with these orders. NIFA is available to answer questions you may have along the way. During your schedule review, your Equal Opportunity Specialist will definitely work with you on ensuring that these orders are implemented into your programs based on civil rights laws, regulations, and policies. But our model doesn't change, and our approach to you it's not going to change at all. This is still a partnership, and we will always work with you to ensure you're compliant with federal requirements. With that said, let's begin. First executive order, Executive Order 14148, initial rescissions of harmful executive orders and actions. The goal of this order is to restore the hard work, merit, and equality back into every agency, institution, office of the federal government. Executive Order 14151, ending radical and wasteful government DEI programs and preferencing. The goal of this order will assist the government in serving every person with equal dignity and respect, spending taxpayers' resources. Executive Order 14168, defending women from gender ideology extremism and restoring biological truth to the federal government. The efforts of this EO will assist with providing dignity, safety, and well-being back to women, to include single-sex spaces and activities designed for women. Executive Order 14173, ending illegal discrimination and restoring merit-based opportunity. The goal of this order is to help ensure fair opportunities in our institutions and the federal government based on civil rights laws, regulations, and policies. The next order, Executive Order 14188, additional measures to combat anti-Semitism. Next slide, sir. Oh, thank you. Executive Order 14201, keeping men out of women's sports. In past years, many institutions and athletic associations have allowed men to compete in women's sports. So it can become unfair and dangerous to women and girls, and denies women and girls the equal opportunity to participate and excel in competitive sports. So the goal of this executive order is to discontinue allowing men to compete in women's sports and bring back the fairness and safety back into women's sports. Executive Order 14224, designating English as the official language of the United States. Executive Order 14281, restoring equality of opportunity and meritocracy. Executive Order 14283, the White House initiative to promote excellence in innovation at historically Black colleges and universities, or HBCUs. HBCUs remain integral to American students' pursuit of prosperity and well-being, providing a pathway to a career and a better life. This order continues to elevate value and impact our nation's HBCUs as beacons of educational excellence and economic opportunity. HBCUs serve as some of the best cultivators of tomorrow's American leaders in business, government, academia, and the military. Those are the executive orders. But next you will hear from Mr. Galliardo about the best practices for continued compliance based on these aforementioned executive orders. Mr. Galliardo.
Thank you, Terrence. Hey, everyone. I'm EOS, Josh Galliardo, and I'd like to talk to you about a topic that I'm sure is on everybody's mind, namely best practices for continued compliance in light of the executive orders that Mr. Maynor just went over with you. So to begin, we've modified our review processes to align with the executive orders that Terrence just described. Many aspects of our compliance reviews pertaining to the legal requirements of Title VI, Title IX, the Age Discrimination Act, Section 504, and the ADA are unaltered. However, elements that have changed or have been introduced to align with the executive orders will require some adjustments and adaptations on the part of our recipient partners. So today we wanted to give an overview of some specific changes that we've made and to describe what we will consider moving forward to be best practices in aligning your civil rights programs with current and operative executive orders. For the purposes of our discussion, we'll first examine some changes that apply to both research and extension reviews, which is to say these existing review areas are common to research and extension, and we examine similar things in these reviews, irrespective of the program type. You'll no doubt be familiar with these review areas because you've seen them before. Organizational capacity is the first such review area. And under our new approach, we will request information about and will examine specific efforts made by recipients to ensure the elimination of any DEI-related offices, titles, positions, programs, and activities, as well as environmental justice and equity planning in accordance with Executive Order 14151, ending radical government DEI programs. Similarly, we will examine efforts made to ensure the elimination of the promotion of gender ideology and related practices in accordance with Executive Order 14168, defending women from gender ideology extremism and restoring biological truth. In assessing your compliance, we would like to see an organized plan or a process to effectuate these changes, as well as modifications to a recipient's non-discrimination policies and procedures if they previously included or referenced what are now prohibited practices. Civil rights knowledge and procedures is another familiar review area common to both research and extension. And in our upcoming reviews, we will be looking to examine whether recipients have modified their civil rights training to comport with the executive orders I just referenced. Compliance best practices will entail revising civil rights training so as to update descriptions of prohibited actions and to expunge DEI or equity or gender ideology-based civil rights practices. As for the review area of public notification and outreach, in upcoming reviews, we will attempt to measure the impact of outreach in the broadest possible terms. We will also look to see the discontinuation of outreach efforts that are targeted specifically on the basis of protected class status. In lieu of specifically targeted outreach, in assessing the breadth of a recipient's outreach efforts, we will examine the geographic scope of outreach to ensure that efforts are made throughout your respective states, including in rural areas. Compliance will be assessed in terms of the quantifiable effectiveness of outreach, as shown by tracking your impact and explaining the geographic reach of your outreach efforts. And regarding discrimination on the basis of sex, in upcoming reviews, we will be looking to see efforts made to notify students, faculty, staff, and the public about reporting prohibited DEI discrimination based on sex or gender ideology, as well as notices made to employees and students about the rights of nursing mothers under the Providing Urgent Maternal Protections for Nursing Mothers Act of 2022. Try saying that 3 times quickly. Moving on. As you know, there are a couple of review areas that are specific to and only really examined within the context of research compliance reviews, namely graduate students and resource allocation. We've altered our reviews in these areas to align with executive orders, so there will be some things that you'll need to bear in mind when thinking about compliance. To begin, in our examination of graduate students, we've shifted our focus to assess merit-based decision-making in grad student admissions and in the awarding of NIFA-funded assistantships, fellowships, and scholarships. So accordingly, in our reviews, we'll examine selection and admission procedures to ensure that they rely upon neutral, objective, non-discriminatory criteria, so as to be in alignment particularly with Executive Order 14173, ending illegal discrimination and restoring merit-based opportunity. So we'll specifically examine selection criteria, verifying whether criteria are neutral and merit-based, as opposed to based on discriminatory criteria, such as protected class status or other identity-related criteria. And in particular, we will ask for data regarding applicants' GRE scores, GPAs, and other credentials, and will assess their correlation with selection or admission. Similarly, we will examine recipients' rationales regarding the use of more subjective selection criteria to ensure that subjective criteria do not serve as a proxy for protected class or for other identity-based selection standards. Compliance certification, therefore, will entail demonstrating that all awarding and selection processes are non-discriminatory and based on quantifiable meritocratic criteria. Concerning resource allocation, our upcoming reviews will seek to ensure that NIFA-funded research projects do not promote DEI initiatives or conduct research with protected class status, diversity, gender ideology, or environmental justice as the focus or application of the research. We'll also examine written policies pertaining to the distribution of resources, equipment, and supplies, again, to ensure that these policies or processes rely on neutral and merit-based non-discriminatory criteria. So best compliance practices will entail the discontinuation of prohibited discriminatory research topics and demonstration of neutral merit-based criteria for the allocation of resources. Relatedly, NIFA itself no longer is conducting parity analyses in its reviews in any area, but particularly in the areas of graduate students and resource allocation, so as to align with Executive Order 14281, restoring equality of opportunity and meritocracy. Our next review topic is a review area that will be appearing only in extension compliance reviews, and it's entitled Protecting Youth in 4-H and Youth Extension Programs. In this new review area, we will request information about whether a recipient's extension programs offer girls-only athletic opportunities or overnight activities, and if so, are there measures in place to ensure that girls or women are not required to compete with biologically male youth or adults in girls-only sports? And are they provided with safe, separate spaces for restrooms, changing rooms, sleeping accommodations, or locker rooms? In essence, best compliance practices entail having policies in place to ensure that participation and access to these kinds of opportunities, facilities, is based solely on biological sex rather than gender identification. And since we will also examine a recipient's 4-H youth curriculum, outreach materials, and training materials to ensure that they comply with executive orders, compliance certification will require making sure that these materials also do not promote DEI or gender ideology. And finally, we'll be adding a new review area that will be appearing in both extension and research reviews called non-discrimination based on race, color, and national origin. Under this review area, we will examine Title VI grievance procedures, complaint processes, and complaints filed pursuant to Title VI to identify possible trends pertaining to anti-Semitism or other forms of national origin and race-based discrimination and harassment, looking to verify the prompt, appropriate processing of such complaints as to align with Executive Order 14188, additional measures to combat anti-Semitism. Compliance in this new review area will be assessed in terms of whether there are specific trends or issues with anti-Semitism or other forms of national origin or race-based discrimination or harassment, and if so, have effective measures been taken to combat it, including, if necessary, specific policies and training. That about covers it for now. So thank you all very much for your attention. And with that, let me pass it along to Shabnam.
Thank you, Josh. I know what Josh has shared seems like a lot, but we believe that working with each other in partnership will allow us to comply with these executive orders while still staying true to civil rights. And so what have we done to help mitigate risk? And also, what are we doing with enforcement? We decided to break it down into two parts. I'll go over NIFA actions first, and then I'll discuss, recipient actions and what we expect you to do as we transition our programs to comply with these executive orders. First and foremost, we spent a whole lot of time updating our compliance review process and dissecting these executive orders and interpreting them and understanding them so that we can, in fact, help you. And Josh did that brilliantly. So thank you so much, Josh. In addition to that, we are going to be providing you with technical assistance, which aligns with the updated process as we conduct our reviews. So it's kind of two-pronged what we're doing. We're going to provide you with technical assistance upon request, and then we will provide you technical assistance as we conduct your review. So we by no means expect you to be 100% in compliance when we come to see you, but we do expect you to be in 100% compliance when we are done with our review. What we have done to also help mitigate some risk is divide your reviews into two parts. There are some 23 and 2024 cases that are still open. There are also some 25 cases that were initiated prior to the issuance of the executive orders. For those reviews, we are not requiring implementation of specific recommended actions. For example, Josh mentioned parity analysis. So when we issue to you our monitoring memos and our responses, you will find something that says that this action is no longer required. And that will help us to also expedite the closeout of these old cases and kind of focus on the golden age of civil rights and bringing it back to the core. And then for the 2025, there's a couple of them that are newer that were issued post the issuance of the executive orders. And we will, of course, work with you to come into compliance and examine all those things that Josh mentioned and also help you if you have any questions. I would urge you to reach out to the individual EOS who is working with you on your case. And again, stress that this is very much a partnership and not something that we are going to kind of throw on you without any, any communication, which is kind of why we're hosting this presentation today. And then the last thing, of course, is the recipient action and what we're expecting from you all. And I think that, as I mentioned earlier, it's a partnership, but also communicating your concerns and keeping an open channel with us because this is a new process, a new perspective, or rather an old perspective on civil rights. We want to make sure that we're not missing anything. So if you do look at our document request and realize that it might need additional information or something doesn't make sense, we do want to hear from you because I believe that this year is a learning year for all of us as we, comply with these executive orders and understand them. I think that is all I have. Oh, questions. As we go through this presentation, if there are questions, please put them in the chat. We'll answer any that weren't addressed in the Q&A. We do very much appreciate you for your time and are thankful that you are here. With that said, I will turn it over to Tyler to talk about the Q&As that we have developed for you all.
Thank you, Shabnam, and thanks everyone for your time today being on the call. Good morning, good afternoon. I see at least one person from American Samoa on the call, so Talofa there. I'm sorry, there. And yes, today I'll be going through some frequently asked questions that we've received, and they're broken up into different categories. And also this recording, just as a heads up, will be recorded and shared on our website, and you all will receive notification once that's been finalized and published for future viewing there. I see some questions coming in, so it's great. Thank you for putting those in there. Again, we will answer those to the best of our ability and follow up later on after the call for those questions that we can't answer today. So first question I've got right here is, are there any changes we may not be aware of? If so, what are they? Or are we to continue the same protocol until we hear from NIFA? So answer here. We have worked, NIFA has worked with USDA's Office of the Assistant Secretary for Civil Rights, or OASCR is the acronym. NIFA, we've worked with OASCR to incorporate the revisions to our processes in order to comply with the recent executive orders there. Two-part question. NIFA, we recommend that you take the necessary steps to do a full review of your programs, services, and activities to make sure they are in compliance with federal laws, regulations, and executive orders. You're advised to reach out to your designated legal rep at the university. If you have an office of general counsel, whoever your go-to person is there, you are welcome to speak with them. And next slide, Gabriel, please. All right, another question we've received are, have there been or will there be changes to the list of documentation that we request? If so, what are those changes? And yes, we have briefly discussed those on the call, what our perspectives are when it comes to being in compliance based on new executive orders, and all FY26 reviews will have this new information. You all will receive the revised data request there. And yep, just again, FY26, the schedule is forthcoming of being finalized and posted on our website. So please hold tight for that. And FY26 recipients, you'll be the first ones to receive that new data request there. Next one, Gabriel. All right, a common question that we receive is on data collection. So what changes can we expect and by when for collecting and reporting demographic information? So data collection is still required. That has not gone off the table. And first answer here, data collection is required of program participants under the Office of Management and Budget's Statistical Policy Directive 15, or for those that enjoy some alphanumeric soup, OMB SPD 15. So OMB SPD 15 is our and other federal agencies' guiding document when it comes to how to collect up data. This document, this SPD 15, came out in 1997, and last March, or March of 24, there were some revisions that were made to this SPD 15. These revisions were made to enhance how federal programs serve all communities, and to have a standard, a unified form when it comes to collecting up data. I mentioned March 24 of last year, there was new revisions that were made to SPD 15. There is a period of time that recipients of federal funding have to switch over to those new standards under SPD 15, and the effective date for those, for all recipients of federal funding to switch over to the new data collection standards is March 28th of 29. So a little under 4 years, 3.5 years from now is when we expect everyone to switch over to those standards. With that being said, at this time, we will accept either data collection standards, so the 1997 version or the 2024 version. We will accept those at this time. Also, when it comes to data collection, previously we have used the terminology reg data collection, race, ethnicity, and gender. We have changed our terminology or switched it over to demographic data collection. So when it comes to the demographic data categories, those, we're not using those. Those should not be used as a determinant of eligibility for any programs, services, or activities, but rather those categories provide a common language for uniformity and comparability in the collection and the use of demographic data by federal agencies. Part 2 with this question, this is just a snippet or a screenshot of SPD 15, this demographic data collection policy. Here's what it looks like on the website. There's pretty straightforward in terms of the categories, what categories to use moving forward, how to collect up the data, and also that effective date of when this goes into effect. And at the bottom there, there is the link if you would like to read more of the nuts and bolts of SPD 15 or review that with your designated legal rep or person in charge. We've got that down at the bottom as well. All right, another frequently asked question we get is on the "And Justice for All" posters that the USDA has. Question here: what are NIFA's expectations regarding displaying the "And Justice for All" and the Title IX non-discrimination based on sex posters? So here, these civil rights posters are required. So AD 475A, some more alphanumeric soup for you, or the green poster, the green "And Justice for All" poster. That one and the orange Title IX poster must be displayed. They are required to be displayed in all public spaces, including virtual environments where NIFA funds are being spent for any program, service, or activity being conducted. And also, recipients must make all reasonable efforts to ensure that the public knows of their right to file civil rights discrimination complaints directly with the USDA. That language is included in that poster. If you're unfamiliar with it, take a look at it, become familiar with it, and it does inform people that, hey, if you feel like you've been discriminated against, you can contact the USDA directly. You all may have your own grievance reporting procedures, maybe a state agency or a university reporting office that civil rights complaints can be made to as well, and that's perfectly fine. That's a different avenue that someone in the public could take if they feel like they've been discriminated against. We've got hard copies. If you're unfamiliar with this poster, we can send you hard copies of that so that they can be displayed publicly throughout locations, regional, county offices, research labs, wherever NIFA funds are being spent. So if you want those copies, you can reach out to my contact or my colleague at his contact information here, Terrence Maynor. This is also listed on the website as well as his contact information. So if you're running low or you need hard copies, you can contact him. If you reach out to one of us, other EOSs as well, we'll get that information to him. While you're waiting for those digital or those physical copies, you can also go ahead and download digital copies as well. Make sure you've got those in virtual environments, links to that, and you can find those here at that link below. All right, next one is on the non-discrimination statement and public notification. So first one here, is a non-discrimination statement required on all publicly disseminated materials? There's a few parts to this question. So first one, is it required on public materials? Yes, it is required that you include a non-discrimination statement that says all services and activities and programs where NIFA funds are being used are conducted in a non-discriminatory manner. This includes putting that on, again, on all forms, whether that's physical forms, visual, electronic forms that you're printing out, audio materials. There needs to be a non-discrimination statement there. Another part of that question was, what about internal documents? We've got a bunch of extension internal documents. Do we have to put that non-discrimination statement on there? So we have a guiding policy that we follow when it comes to public notification, non-discrimination statements. And you can see here, that is the USDA Departmental Regulation 4300-003. And that's on equal opportunity public notification policy. It is our most up-to-date guidance that's available online that has expired October of 2024, but you all are advised to continue using that October 2024 expired public notification policy until a revised one is made available. This policy does not explicitly state, yes, you must put the non-discrimination statement language on internally disseminated documents. It does not explicitly state that. But as a good or best practice, recipients are encouraged to include that on internal documents. And another question was on the exact wording. What do we have to put in there as our non-discrimination statement language? And what's this about an abbreviated shortened statement? So the exact wording, including the list of federally protected classes, is included in the website link that's displayed there below. And that's the full DR 4300 on public notification. And it details when to use that shortened or the abbreviated statement as well. So again, you all are encouraged to look over this policy with your leadership to see if there's any compliance issues or things you're doing well when it comes to non-discrimination statements. All right, we've received several questions as it relates to DEI compliance moving forward. So this question, some states have banned the use of DEI terminology for jobs, activities and programs that colleges and universities can do. Does this affect how outreach activities such as demographic data collection, does that impact how those are done at this time, and how targeted efforts are made for underserved communities? So yes, again, reiterating that recent executive orders prohibit DEI programs or preferences in federally funded programs, which also prohibits gender ideology and prohibits illegal discrimination to make efforts to restore merit-based opportunities. Again, you all must ensure that your programs, your services, and your activities are conducted in a non-discriminatory manner across all service areas, including rural communities. And again, you all must comply with the recent executive orders by making efforts to eliminate any prohibited DEI-related offices, titles, positions, programs, and activities, as well as any prohibited actions that promote gender ideology. And at this time, regarding demographic data parity or barrier analysis, we at NIFA will not conduct that. We will not review it or require recipients to conduct parity analysis of participants in your programs, services, and activities. All right, one more question here as it relates to DEI compliance. And this one, hey, what are the federally protected classes for USDA assisted programs? It's not a quiz, but if you know it, good job. So the protected classes, the federally protected classes are discrimination is prohibited under the bases of race, color, national origin, sex, age, disability, and reprisal/retaliation for engaging in protected and prior civil rights activity. So those are our fairly protected classes. None of them may be removed from any non-discrimination statements, assurances of non-discrimination letters. None of those classes may be removed from any non-discrimination statements. Again, reiterating, you all must take all steps to ensure that your programs, services, and activities are conducted in a non-discriminatory manner across all service areas. There are instances, a local city or state law that may offer some protected classes that are not covered or under the federally protected class umbrella. If there are those state or local protected classes that you want to include in your non-discrimination statements, your assurances of non-discrimination letters with partners or subrecipients, we strongly encourage you all to discuss with your designated legal representation or Office of General Counsel about adding those protected classes. Again, adding those protected classes based on any local or state laws in your area. All right, here we have some updates on language access. So, are there any updates on language access or limited English proficiency requirements in order to comply with civil rights review purposes? In March of this year, Executive Order 14224 was issued, and that one is designating English as the official language of the US. So back in March, that got issued. And in next answer, Gabriel. And a few months later in July, the Department of Justice issued an official memorandum on how to implement this executive order. That memorandum from DOJ says, hey, we're going to issue formal guidance within 180 days that makes it clear, that makes the guidelines explicit on when to prioritize English, while also explaining precisely when and how multilingual assistance services remain necessary to fulfill missions and efficiently provide government services. And the deadline for the DOJ to issue that further guidance is just a month away in January. Until this further DOJ guidance is released, you all can still continue providing language access services to LEP populations. You're not prevented from doing that. And this executive order on designating English as the official language of the U.S. Does not apply to and does not impact language services that are provided for individuals with disabilities. And that could be observable, non-observable disabilities to you or I. So if someone needs interpretation, translation services for equal access for programs, services, and activities as a person with disabilities, you're still required to provide those. And then I am certain that not all questions have been answered with these FAQs. And if you would like to get your questions answered, I know we had some in the chat, but if there are questions after the fact and you would like to have those answered, how do you do it? Tyler, tell us how you do it. And you can do that by reaching out to myself. My contact information is up here on the slide here. And you can see here my email address, tyler.hayes2@USDA. There's more than one of me here. And if you have questions, again, you can reach out to me after the call. If you're more comfortable reaching out to your equal opportunity specialist you've worked with, that's perfectly fine as well. But I'm here to answer questions, and our office will work internally to get those answered for you. And when it comes to the FAQs, I am going to, that's all I've got in terms of FAQs we've received so far. And I think now I'm going to pass things over to our guest, Ms. Ramonda Reed.
Good afternoon, everyone. My name is Ramonda Reed. I'm the Director of the Compliance Division within the Office of the Assistant Secretary for Civil Rights. You'll also know OASCR as the Office of the Assistant Secretary for Civil Rights. That's the acronym we're most commonly known and referred to. So OASCR provides leadership and direction with regard to civil rights within USDA. We work really closely with NIFA's civil rights team, who has been presenting with you all today, to ensure our compliance review process is robust and effective. We've had recent executive orders that have been introduced, and they've resulted in important changes to civil rights requirements. So we've worked together to ensure we have responses. One thing that I did want to point out during this discussion is OASCR has updated our departmental directives. We've updated the non-discrimination statement, as well as the injustice for all posters in response to the executive orders. This information is available online, but it's also available upon request. As noted during Tyler's presentation, Terrence is also the point of contact with regard to injustice for all posters. So one thing that I did want to know is today's discussion about recent changes and best practices is very essential. We appreciate your partnership as we navigate these changes together and work to ensure full compliance across all programs and institutions. Our goal is straightforward: to provide clear guidance and support you as you implement these requirements. NIFA has been an excellent partner in this effort, and they will continue to be your primary point of contact. If questions arise whether about implementation, interpretation, or any specific compliance issues, please work with NIFA and they will coordinate with us to ensure you have everything you need to move forward confidently. Thank you. And with that, I'll turn it over to Vidal Gray.
Okay. Well, first of all, I want to thank everyone that participated in this presentation. So all the team members that took their time out to put this together. And Ramonda, thank you for coming down because you provide additional support for us all the time. So we really appreciate you. We couldn't do what we do without you. So we really appreciate that. Some of the things that, some of the small notes I was told, talk about enforcement. So this is going to be real short. When we talk about enforcement and making sure that everyone is in compliance, we got to work together. We're not your adversary in any of this. We're going to work with each and every one of you, my team members that deal with you on a daily basis, weekly basis, monthly basis during these reviews. We are here for you. So understand that we're here for you. And that's just the bottom line. So we're not going to have to worry about enforcement because we're going to help you get into compliance. And then that's going to be the end of that. I'm glad you brought up the Injustice for All posters, Ramonda. So it seems like they have been updated fully. One of the questions were they going to be limited? We're going to have to replace all Injustice for All posters for all of our stakeholders. So at the very beginning, it might be limited for the moment, but we will get you at least as many as we can. And yes, you can print them out and post them on your own. Please make sure they're the appropriate size as outlined in our directives. I know we provided a lot of information for you today, and it's a lot. And I see a lot of the questions in the comments section, but we won't respond to many of them right now. What we need to do is we'll take those questions, our staff will review them, provide a response, and then we have to make sure that legal agrees with our response, and then we'll put them out. I will tell you that at the end of this, our intent is to post this recording and any questions and answers that we can within 5 days. That is our plan. And we're going to try and adhere to it, but however, it might be adjusted to the right or to the right, depending on the situation and availability of our Office of Counsel review. Pending anything else, that is going to be it that we have as far as today. Once again, I want to thank everyone that participated, presenters, and I also definitely want to thank all the participants that came in because it just goes to show that you have the same love that we have for your organization, and we're just trying to make sure that your organization is successful moving forward. And that's all that we have for today. Thank you very much. If you would stop the recording, please, and thanks.
I'll do that now.
Thanks, Todd.